typically our paramedics are fact witnesses. So we want to know what you saw, what you did. And so, but it is critically important because I'm not calling you up to stand just to fill up more space. I'm only calling people who I believe are absolutely essential to prove this case.
Welcome to In Service, the EMS podcast, where frontline experience meets leadership insight. Hosted by Jason Falvey, a seasoned paramedic and EMS leader with over 30 years in the field. This show brings you conversations with people shaping emergency medical services today. From street-level medics to innovators on the bleeding edge of EMS, we dive into real stories, leadership strategies, and what it takes to build high-performing teams in high-stakes environments. Let's get in service.
We copy you down, Eagle. Tranquility Base here. The Eagle has landed.
Today's guest is a seasoned prosecutor and former college athlete who played baseball at Southern Poly University before earning his law degree in 2012. As Deputy Chief of the Organized Crime and Gang Unit in Cherokee County, he's tried 100 cases involving gang offenses, drug trafficking, and organized retail crime, and regularly shares his expertise on RICO, gang prosecution, and trial testimony. Today, he'll dive into strategies behind complex prosecutions and explain how paramedics and EMTs can prepare for courtroom testimony. Welcome, Damion Overstreet. Good morning.
Thank you. It's good to be here.
Yeah. So very excited about this because I know it's a concern to EMS providers getting that subpoena. You know, we're so focused on delivering the best care that we can. When you get that subpoena, that is just a foreign world to us, right? And we see the crime dramas with the courtroom testimony and stuff, but still, for you, you deal with this all the time. But for us, man, that is something scary.
Well, I can tell you it's not just limited to EMS and paramedics. We get it from our law enforcement, we get it from our civilian witnesses, and we get it from our fire staff as well. Everybody gets nervous when it comes to the courtroom setting. In reality, there's no need to be worried at all.
Right. Where'd you grow up?
I was born in Georgia, moved to Maryland when I was younger, lived in Maryland until I was about 12 years old. My father was in law enforcement for many years, so I think I was kind of groomed a little bit to be into the prosecution. Well, but I was always the defense attorney. And so I went to law school with the mind that I wanted to be a defense attorney, but that changed pretty quickly. But so I grew up in Maryland. I was very active. My family is a huge sports family, so I was fortunate enough to be able to play 1 year of college football at Western Carolina, and then I actually transferred and played baseball at Southern Poly in Marietta. I played a baseball there. Wow. So huge sports fan. And then my family has businesses, so I assist them with their business stuff. And then I work at Mercedes-Benz Stadium. In my copious amounts of free time, I do stadium security there. So I stay busy, but I really enjoy being busy. And I get to meet some really great people just in my different experiences of being at the stadium and doing security. And it really helps me with my ability to interact and engage with witnesses from all different walks of life, just from having those experiences and dealing with different people. So I think I do all the work that I do because I think it helps really cultivate my ability to be a better, more understanding and interact better with jurors and with witnesses.
Tell us a little bit about what your role is in your position.
So I am the deputy chief over the organized crime and gang unit. And so in that role, I work with 3 other ADAs. They're great ADAs, Kelly Chavis, Megan Hertel, and Rachel Murphy. All of them are outstanding prosecutors. And then each of the attorneys have an investigator, Dan Worrell, Kyle Smith, Bill Presnell, and then Chad Venesia. And then as well, we have an analyst that helps us because we do a lot of cell phone analysis. Blair Wing is an analyst, and then we have an administrative assistant, Tabitha Jenkins, really runs the show. She keeps our schedules in line, and so we really have a great team. And so my job is really to help them. I have a courtroom that I'm assigned to, and I have cases that are specifically mine, but really my job is to help them, to give them the tools that they need to be successful, to talk with our DA about things that we can do to help stem some of the organized crime aspect we have and gang aspect we have in Cherokee County. I do a lot of teaching to law enforcement. So in my role, it's really to help help my team be successful, and then to help law enforcement be a good liaison to our undercover narcotic squad, to our gang investigators, so that we can help make better cases.
Yeah. Well, recently we talked a little bit about this. There was a case up in Boston where a paramedic had to recently testify, and it just didn't look that good at the end of the day. And I think it was the cross-examination component of it. And you looked into it, right?
I did. I didn't follow the case very much. I actually watched the verdict just because it was in our office. But I went back and I watched specifically the cross-examination of the EMT in that case, because I wanted to see what was so concerning during that testimony. And a couple things jumped out to me. And really, it is the same concerns that we have pretty much with every witness in every case. And again, it's something that with a little bit of preparation, I think can easily be taken care of.
Great. So what is the importance of testimony? Give us a little overview.
Absolutely. So number one, with any witness is credibility. You are there for a specific purpose, and that is to speak facts to the jury. Your credibility in front of the jury is paramount. And so your testimony is evidence. Your testimony or evidence is given the same weight as the knife that was used to hurt somebody or the gun that was used. What we say, weighing the evidence, the testimonial evidence and the physical evidence carry the same weight. And so the only issue with the testimonial evidence is the credibility of the person providing that is another factor that the jury gets to weigh.
Right. And the defense attorney is going to try to undo that. He's going to make you look not credible. And that's kind of what happened in that particular case.
Absolutely. The number one goal of a defense attorney is typically to ding the credibility, because when you can ding the credibility, then they can go from there and say, hey, did you do this right? Did you do this right? And that's really the way that law enforcement gets hacked sometimes. What you didn't do is something that they go and then they make that link to, are you credible? Well, you were trained to do this. Why didn't you do that? And so that is typically in every case, they want to attack credibility, number one.
So what is the ultimate goal of the paramedic on the stand?
So the ultimate goal for me, when I'm putting a witness up there, I have a very specific purpose. And so understanding what the prosecutor is trying to get out of your testimony. I don't put witnesses up there for no reason. I put you up there for a specific purpose. And so your goal as an EMT paramedic typically are going to be fact-based. What you did, what you saw, and that is really where we're going to live in your testimony most often. There are always those instances where you need to expand. Maybe somebody said something to you that wouldn't typically show up in your patient care report. Those are things that would be different. However, when you're on the stand, we're going to focus typically on what it is that you did, and you're leaning into what your expertise is, the care you gave, why you gave that care, what you saw that led you to give them that type of care. So we're really living within the area that is your EMT's expertise.
Right. So expand a little bit on evidence versus testimony.
Of course. So evidence is the overarching kind of theme, right? Evidence is the means by which an issue is established or proved, right? So we're at trial. We need to prove beyond a reasonable doubt what we call in the legal side, the elements of the crime. Did you meet those elements? And so the evidence is used to prove those facts that are at issue, right?
Okay.
And so included in that is the testimony of witnesses, which testimony is a piece of evidence, just as same as the exhibit. So when we tender an exhibit, being the gun, whether we tender it being the knife, whether it be a medical report that outlines the injuries or coroner's report that outlines the cause of death, those are all pieces of evidence as well. And so what evidence is not, it's not going to be the indictment. It's not going to be the accusation. It is only the testimony that is given during the trial and the exhibits that are tendered. So you'll hear the judge in every case say, the opening remarks, the closing remarks are not evidence. So I get to stand up in front of the jury and tell them what I think the evidence is going to show in opening.
How you feel about it.
How I feel about it. The defense is to do the same thing, what is not there. And in closing, I get to say what I think the evidence shows, why they can convict somebody. And the defense is going to say what is missing, what's not there, why they should not convict, why the state has not met their burden beyond a reasonable doubt. None of that is evidence. The only thing that is evidence is the testimony from the witnesses and the exhibits that are tendered into evidence. That is all the jury is to consider as to whether they can find a person guilty or not guilty.
Right. Let's walk through the process. You send a subpoena out because you want to bring in the paramedic to testify.
Absolutely.
What happens following the issuance of that subpoena?
Sure. Hopefully that subpoena comes to you well in advance, not the day before. But typically what the plan is going to be is how my process is the investigator get together and we plan out what witnesses we need, what evidence we need. I've read your reports. I've reviewed it. I typically have drafted out direct questions so that we can discuss. Because when you come in to meet with me, my job is to prepare you to testify. I want you to understand what your role is within this testimony. I say, this is what I need from you. This is the one thing that I need from you to get in, to prove my case. And this is how we're going to do it. So I'll talk with you about questions. Different witnesses are more comfortable than others. Some of them, we just come in and we have a conversation and we talk and we show them the evidence and they're good. Others, they want to know. So we'll do a walkthrough. We can say, hey, I'm literally going to ask you these exact questions. Ask them and let them give me the response. We can discuss it. We can talk about some areas of concern. Whatever you need as the witness, my job as the prosecutor is to put you at ease, put you in a position where you're comfortable. Another thing that I want to do is explain to you any maybe quirks the judges have, any quirks maybe that defense attorneys have, areas in my experience that can set you up for success. That is my goal, is to get your testimony to be concise, get your testimony to be on point, and to show the jury that you are a credible witness. And so I have a method that I'm comfortable with doing, but I'm always willing to adapt and learn because at the end of the day, you're up there on the stand. I only get to ask you a question. You're the one that has to answer it. So whatever I can do to put you at ease is really what my job is.
Right, right. So you can get that thing out that needs to get out.
Exactly. You're there. Typically, our paramedics are fact witnesses. So we want to know what you saw, what you did. And so, but it is critically important because I'm not calling you up to stand just to fill up more space. So I'm only calling people who I believe are absolutely essential to prove this case. And so if you're being called, you should understand where your role is and where that plays in relation to how I'm presenting my case. And that's something that when we meet and we prep, I want to explain to you. This is where you're going to be. You're the fourth witness. Here's why you're here. This is what we're going to do. And this is what comes after you. And this is how we're going to put it together. And this is where you play within the grand scheme of this entire trial.
Excellent. Are they meeting with the defense team?
Sure, they can. So I will never tell a witness of mine not to meet with the defense attorney. I shouldn't do that. I say you can talk with them if you want to. I typically, especially for our law enforcement and for our other public servants, I'll say, look, if you don't meet with them, if you don't answer some of their questions, they're going to ask you the same question that I've heard a million times. I tried to talk to you, didn't I? Yes. And you didn't want to talk to me, did you? No, I did not. But you talked to the state before this case, didn't you? So what they're doing is trying to get to your credibility by showing that you have bias, that you're not there to tell the truth. You want this person to be convicted. So you're only meeting with the state. You're only helping the state. You're not trying to help us seek justice, as they like to say. And so I tell my witnesses, I say, look, talk to the defense attorney. I have nothing to hide at all. The only thing I ask is when you talk to him, call me back and tell me what y'all talked about. It will help me. One, it will help me to prepare you. Say, okay, what did you talk about? I can sometimes get how they're going to specifically attack you, what areas, so I can prepare you better. Or maybe we've already prepared you for that. And I can say, okay, see, so you understand we've prepared you what they're going to ask you. It's up to you to say no, that you don't want to talk to the defense attorney. But if you do, just know that line of questioning is going to come without a doubt. There can be reasonable accommodations, Yeah. And so if they call you on the eve of trial and you're working an overtime shift and you can't, just say, hey, sir, I'm sorry. Can I do this over the phone with you? Can I, you give them some reasonable accommodations, because very quickly after they've called you and you've let me know and you said, hey, I couldn't meet with them because I'm on an overtime shift and I can't get off. And I said, I'd be happy to meet with him another time. When he asked you, you didn't want to meet with me and you went with the state. I can follow up and say,
I was working.
Isn't it true you were working, and did you offer another time to speak with him? So it wasn't that you weren't willing to meet with him. They just called you on the nth hour when we've prepared months in advance.
If they're preparing a vigorous defense, they want to win and get their client off. They're getting paid a lot of money to do that, most likely. What's out of bounds for them to ask?
At the end of the day, they're limited, and so is the state, to relevant evidence. So what is relevant is what has put this fact at issue. Is it something that is tangential to that is still somewhat related? So what it has to be boiled down to, what is relevant information? What is relevant for a jury? It can't be for wasting time. It can't be to confuse the jury, which are typical things that sometimes we'll see the defense wants to talk about other cases. And so we would object to relevancy. So that's the way that we try to combat that and keep the case streamlined, is to prevent the defense from getting into things that are not relevant directly to this case.
Is it relevant how many hours you worked prior to that particular call you ran, the meals you ate, the amount of sleep you got?
It can be. The meal you ate, I would say probably no, but if you had worked a double and maybe they were trying to allude to that, maybe you misremembered because you were very tired. That is the leeway that they will likely get from the court, and I probably wouldn't object to relevancy on things like that. But what you ate, things like that are not relevant in my opinion. I let the defense have a lot more leeway to ask those questions that may not be relevant, because my goal is to be very concise and on point and direct. And so when you start drawing out a trial with unnecessary questions, the jury tends to tone out. So it is a strategic of whether I want to object or not, but those are in bounds. And what are in bounds questions for an EMT could be, like I said, how many hours you've worked, how long have you worked in this career, what was your prior career. If there's an accident or something like that, they might ask you, have you seen and been in similar situations? What their job is to do is maybe to draw where you've done something different here and try to narrow down as to maybe why something different was done, if it can be beneficial for their client, or if it somehow can ding your credibility or the credibility of someone else by your testimony. So just be very wary when they're asking these questions that you feel are nothing questions. They're typically walking you down a line of questioning to get you to that one thing where you're trapped. And so just be very careful. My job, again, is to prepare you for some of those, to typically predict what they're going to attack you on, to prep you for that, and help you understand how we can use our evidence. I like to say we like to recycle our evidence. So when they get you going down these things, talk about what evidence you have, why you did that. So I'll tell you about, I saw this, I heard this, and then you're direct. And when they're crossing you, when they're asking you, reference back to those things. Like I said on to the prosecutor, I saw this, I heard this, and use those as part of your answers when it makes sense to use them.
Right. Talk a little bit about run reports or the documentation. What should go in that report versus what shouldn't go in the report? And you may not have any feelings about that.
So it's not often that that I read through a run report. More typically, we'll read the fire reports and things like that. But again, you're there for a specific role, which is to perform treatment. And so we expect to see the treatment aspect. So when you're putting information in, whatever you put, if you feel that you need to add something to it, it needs to just be accurate. I don't need anything special. All I need is the truth. All I need is exactly what happened, the who, what, when, where, why, that you can able to do. Don't guess, don't speculate. If you see an injury that appears to be a knife, I don't need you to say it's a knife. Just stick to the facts is really what I want you to do. And then, because if you say you think it's a knife and it turns out it was the end of a phone or something that caused a weird laceration, that's going to be an area where they're going to start saying, oh, look, it's reasonable about this EMT who has extensive experience, 20 years experience as the EMT, said it was a knife, but the state's saying it's something here. So don't insert that doubt when you can.
Right.
Stick to the facts.
Yeah, right. It could make you look less credible.
Absolutely.
Right.
Absolutely.
How about things that are said? You're at the scene, you're treating the patient, and somebody says something near you. Hey, that was the guy that did this, or that guy was the shooter, or whatever it was, right?
Very similar to kind of what the defense...
It's not relative to the care we're delivering.
Right.
But somebody said it, you heard it. Does that go in the report? Should it not go in a report? Should it be in a separate incident report?
If you heard something very specific, I need you to be very specific. If you're going to put it in a report, which I would prefer, I need you to be very specific. But more importantly, what I need you to do, because your primary role on scene is providing care, not the investigative aspect. Get with a law enforcement officer, make sure you notate it in your report, but get with a law enforcement officer, say, hey, this person said this, and let them follow up. Let them follow up with an investigation. We don't want to distract you from your primary purpose, which is providing care to a person. But if there's not an area on your patient care report, or you feel that you can't do it, as robustly as you feel you need to, do a supplemental report. Make sure that's attached to your run report. You don't have to do it right there. Law enforcement doesn't write the reports immediately after it happens. They write them a day or two later after reviewing their body cam. So take a moment if you need to. If you feel you need to add that supplemental report, go ahead and do that. Write a good full report that outlines everything you heard to the best of your ability. But I would tell you, in the moment, get them to a law enforcement officer as soon as possible, or at a minimum, get somebody who's not actively treating that patient to at least get the name of the person who said that, so that we have something to follow up on to give to law enforcement.
And it could be something to the effect of your partners going back to the ambulance to retrieve a piece of equipment and somebody says something to them.
Correct.
Right? That's probably not going in your patient care report because it's not related to patient care.
Correct.
But you got to get with the police officer and let them know.
Correct.
Right.
Yeah, and that's going to be part of what is it and what's going on. I know sometimes you're singly focused on that care and maybe not know everything that happened around it, and so you may not know the relevancy of it. But let's say that you heard something and you didn't put it in a patient care report. When we meet to go prep our case, that's the time. I always say, now's the time. Is there anything that you know that's not in a report that you haven't told me that we need to talk about? And so that would be a time. So if for some reason it wasn't in a report and an officer didn't get the follow-up, that would be the time for us to discuss it, to be able to go through that and figure out what we can do. Is there anything that corroborates that, or is there anything that we need to change in our presentation because of this new information? But at the end of the day, if you hear something, make sure it's known to the prosecutor. Even if you have to beat us over the head to tell us, we need to know that information. I always say, I need to know before you get on the stand. If there's anything that you know, don't let me hear it for the first time in your testimony. That's not a good feeling.
Yeah, I bet. That's awful. Nobody likes to be ambushed.
No.
Especially the prosecutor.
And the thing is, how that will play out is if you tell me something, and typically it's something that's going to be good for the state. And so if you say that, I'm going to be surprised, the defense is going to be surprised, and the question from the defense is going to be, well, this was very important at the time, wasn't it? Yes. And today's the first time you've said it. You didn't put it in a report. You never told anybody. And so they're going to, again, use that to ding your credibility.
And I think that actually came up in the case I was referencing earlier in Boston a couple of times. Like, you never mentioned this before.
Exactly.
And that's exactly what the defense did.
So in that case, when I was looking through, what I saw was nothing crazy from the defense. It's the typical avenues that they explore. You had a statement from an EMT that they didn't see any injuries. And then they had a statement where they saw, I think you recalled it was raccoon eyes and a black eye.
Right.
And so the defense attorney had to walk him down that path to get him to admit, you said you saw no injuries, but now you're saying you saw a black eye and raccoon, and you would agree those are injuries. Yes. Again, ding the credibility. The other issue that they really focused on was inconsistent. So that's an inconsistency. Was another inconsistency when the EMT paramedic, he was talking about a statement that he heard the defendant in that case say, which was, I hit him. And so they didn't attack so much that he heard it said, it was the timing of when he heard it say. So they attacked, he said he was performing CPR, I believe, at the time. And then the body camera of the law enforcement officer showed that it did not occur. And so then the officer, the EMT had to say, well, it actually happened at an earlier time. And so, again, those little things really hit the credibility of that person. So, and those are big pieces of evidence. Her saying, I hit him, an injury to a person, those are important aspects of that totality of that case. And so that credibility was dinged because of the inconsistencies of when he said it happened. That's why it's important to, prior to meeting with me, think about the scene. You were there. I wasn't. So think about the distances. Think about how things moved. It's a chaotic scene many times, but we're trained to kind of calm down, right? We know that, in that moment, y'all focus, and that's what's so good about your training and law enforcement training is the ability to focus and do what needs to be done in these chaotic scenes. Lean into that. Focus on what it is that you're doing, but think about that now before you meet with me and say, what other things do I remember occurring? how far were things? What are the distances from here to there? What did I observe that doesn't go in a PCR report, but I recall? These are things that I like to know so I can better prepare you and I can better defend you when you're attacked on credibility.
Right. What about something the patient says to you in the back of the ambulance? You're transporting this patient. Maybe the patient died afterwards, right? That's kind of an important piece, right? You're alone in the back.
Yes.
The person says to you at the last minute before they expire,
John did it.
It was my wife.
Right. So
that's a big thing,
yeah,
right?
That's a huge thing. And so, yes.
You're going to want to write that down.
Absolutely.
You might want to make a note.
You're going to write that down. You're definitely going to let law enforcement know. And those things, and legally, we call those dying declarations. So everybody knows the word hearsay. Hearsay is
let's talk about that.
Hearsay is an out-of-court statement made to prove the truth of a matter asserted. Law just likes to have a lot of words that are difficult. Basically, if you say something that you have the confrontation clause, the Sixth Amendment, where you have the right to confront your witnesses against you. So if you say something, you're not sworn under oath and you're not in court, then that is hearsay. Because there's ways around it to argue it's not for the truth of the matter asserted and all these other things, which is just a whole nother realm we're not going to go down.
See, I thought hearsay was, it's something somebody else told me about the case.
Mm-hmm.
But I didn't hear it specifically from the person involved, but it was, Mike, I'm confusing this, right?
That is hearsay, right? That is hearsay. So you got to remember who said the statement, right? So the person who said the statement is the person who could be confronted, because if I tell you something and you're testifying to the jury about what I said, he's not confronting the witness who said it. He's only confronting the witness who heard it.
So going back to the thing I brought up earlier, so if a bystander says to me, hey, that guy was the shooter, that guy walks away from the scene, how relevant does that become at that point?
It could be very difficult.
Because you can't confront the person that said that to me.
Right.
You can't get them on the stand because we don't know who he is.
Right. So I would argue different exceptions to hearsay. Excited utterance.
I have those all the time.
So there's ways you can do it, because at the end of the day, you don't get hearsay in because the importance is the veracity of the statement, right? You want the person should be able to confront that person who said that, to challenge them to cross-examination so that the jury can judge their credibility, the judge can judge their credibility, and we only want, the veracity of the information. We want it to be truthful information. So we don't want to play the game of telephone. We know how that typically works out. There's slight changes of information, and that those slight changes in a criminal case can pay huge dividends. And so we want to avoid that.
Would that be something they would allow in, though?
So
bystander told me that the man I'm treating is the shooter in this case.
Possibly. It's very possible. I would argue, based on the circumstances, what's the proximity to the crime? Did he have time to create a story? So these are things where we would have pretrial motions. And so that's another thing that potentially you could be called in for is a pretrial motion. We do these motions so we can know what evidence is going to come in, what evidence might be excluded in advance of trial. We don't want to show up and then find, hey, we lost this major piece of evidence we're not going to get in. So but the same process as we talked about for trial would be the same for a motion. We would prep you. You would know what we're here to do and things like that. So, but hearsay is a big thing. All I would say is all you can do is document. Let me worry about how we can use it, if we can use it, if we cannot use it. If you hear it, document it. And that's the best way to arm yourself with that knowledge is if you hear it, document it. Let me figure out how to use it if we can.
Good. So we've talked about the subpoena. We've talked about the meeting with the prosecutor, right? And how important it is that if you heard something, say it, right? You don't want to find out on the stand. So day of testimony comes up, right? Day of trial. They arrive. How is that going to look?
What's the day y'all are dreading, right? It's the day that you don't want to happen. And I told you this earlier. As a trial attorney, as a prosecutor, this is my Super Bowl. This is the day.
The big game.
I do this job for trials. The most exciting and the most stressful part of my job is the most fun. It's also the part that every other person in the courtroom hates the most. All my witnesses don't want to be there. The jurors, typically, they don't want to be there right there. That's why it's called jury duty or serving on a jury. But so the day of, you should feel comfort knowing that your job is only there to be the truth. Your job is only there to speak the truth. You should understand the setup of the courtroom, dress professionally. I'm not saying you need to. I always say, wear what you would wear to church, as long as you don't wear sweatpants to church. Like, don't wear jeans. I'd prefer to wear a nice pair of slacks. You can wear your uniform if you want to, but dress professionally. You are representing not only yourself, but you're representing your business that you work for. You're representing, your department, your agency, things like that. So you want to put your best foot forward.
And it lends itself to credibility as well.
It lends itself to credibility. You come up and you're not kind of, sloppily put together. It will affect your credibility. Jurors, they are gleaning for anything to understand. They're looking for anything to give someone credibility, to believe somebody or to not believe somebody.
This guy's a mess. Look at him. He showed up like that.
Yes. And so, don't chew gum, don't have a dip in or something like that. Like, what you're wearing on today is perfect, things like that. So that's part of the preparation. Come in. What's going to happen typically is you're not going to probably see me the day of. If you're my first witness, you might. If you catch me right before lunch or after lunch, you might. But typically, I'm going to have you meet with my investigator or one of our victim witness advocates. Our office, all DA's offices have advocates, victim advocates who help us, who they typically will meet with victims, and we'll get you connected with either them or investigator. We'll put you in a
so you'll designate somebody to greet them.
Tell you where to be, what time to be there. We really try hard to not waste your time. We want to minimize the time you have to be there. And so show up on time. It's really important. I pride myself in making sure that I'm not telling you to be there at 8:30 in the morning, but I know you're going to be my last witness, which means you might go at 5 o'clock. I don't want to do that to you.
Right.
So if I say, hey, we need you here at 1 o'clock, be there at 12:30. Be there at 1 o'clock. I typically will build in a little extra time for you, but communicate with me. If you're going to be late, let me know. But really make sure you're on time, because I make sure that I treat your time with respect. And so I want to make sure, because sometimes we go faster.
And it's going to throw you off, right? If I'm supposed to be there at 1 and I show up at 2 o'clock, everybody's not sitting around waiting. You've got to change up what you're doing. This is the Super Bowl.
Well, and this is where it's very important, because knowing your order and where you are, because if you heard if I'm calling, you in your position in the trial, and I have to then put somebody out of order, it does have a ripple effect.
Timeline's off at this point.
The timeline can be off, and also the introduction of evidence can be off too, because I can put in certain things after you testify that maybe I can't put in before you testify. And that right. Then I have to switch things around. I'm certainly flexible. Things happen. But to the extent you can control it, be on time, and let's let this trial run as smoothly as possible. I don't need any additional stress on the day. That would be very nice.
Yeah.
You and I will both be stressing. You're testifying. I'm doing direct. You will both be stressed out equally.
Man, where is Jason? What the hell is wrong with that guy? This is important.
I wish I could say I did it as calmly as you said, but yes, that's exactly. It's normally my investigator texting furiously, like, where is he? Exclamation points, and maybe some 4-letter words in there too.
Yeah. So it's time. Somebody's going to come out and get you, bring you into the courtroom. What happens as you come through the doors?
You'll have a bailiff that will show you which way to go. They typically don't want you to go by the defendant, so they will just go in there, look. I'd always turn and kind of tell my witnesses and kind of direct them how to come.
But it's a formal process. Right?
It is a formal process. Once you step in that courtroom, make sure your cell phone's turned off. If you have gum, take it out, put it in your hand. So I'm going to get you up to the witness stand. Don't sit yet. I'm going to swear you in. It's going to go, we raise your right hand, swear affirm the testimony you're about to give, and amount of opinion before this court should be the truth, the whole truth, and nothing but the truth, so help you God. Again, we're reiterating you're there for one purpose, right? The truth, the whole truth, and nothing but the truth. So lean into that. And then you're going to sit down and say, go ahead and sit down, get yourself comfortable, adjust your microphone. I want you to be able to hear. And if you want a sip of water, they typically have water right there. Remember, when you're answering my questions at trial, it's for the jury's benefit. So
Gotcha.
you can position yourself in your chair where you can see me out of the corner of your eye, but you're really answering to the jury. Common thing, you see it more and more, but it's something that you probably don't think about until somebody tells you. But it's not a trick. It's just natural human instinct, right? People want to believe people who are looking at them. And so my job, again, is to help you be successful.
Yeah.
So the first part's going to be what's called direct examination. And that's
Good.
me asking you questions. And guess what? We've prepped. You should know what I'm going to ask you. My joke that I tell my witnesses is, and I'm going to say it the nicer way, is there should not be a single question I ask you you don't know the answer to. So there should not be I don't know that, Mr. Overstreet. So
what? Why didn't you ask me this before?
Because
what are you talking about?
Because after we prep, you will have my cell phone, you will have my email, and I will say you can call me anytime, day or night. I will get back with you to answer your question. I want you to be successful. We all work different hours. If it's at 2 a.m, I might be sleeping, but I'll get back with you. So it's the preparation, right? I can't reiterate how important preparing you is to me, right? That is my job, is to prepare you. If you do poorly as a witness, it's because I didn't prepare you. That's the truth. I've never had a witness that did bad that was really the witness's fault. It was my fault. So we're going to do direct examination. You're going to know my questions. We're going to know what your goal is, what your purpose is, what evidence is coming in for you. And then the defense is going to get to ask their questions. That's called cross-examination.
Let me hold you up there. Have you ever had a witness give you an answer other than what you expected during direct examination?
Sometimes they will
phrase it differently.
If you phrase it differently, it's okay. Sometimes everybody gets nervous, and sometimes they forget. Sometimes they're just in a routine that they kind of have, like how they're going to present it, and they have it in their mind, and something happens and they answer a question differently. So I have to kind of rework the question in a different way. It's happened.
But it's not going to be a mystery at this point. They know what you're going to ask them. You know what they're going to say.
And again, my job is to be able to pivot on those moments when I can sense maybe there's some hesitation or maybe you're not remembering. And there's ways that I can help you. Hey, you did a patient care report, correct? And would that help you recall this? Yes. Showing is this your patient care report? Yes. Read it. It's called refreshing your recollection. So we do that with law enforcement. If they forget specific dates, times, tags, we ask to refresh their recollection. Now, you don't get to read it, right? You have to look at it and say, oh, that's right. I did write this. It was this.
Oh, right.
So
you can't read from it.
You can't read from the report. So I would say...
But you can read it and then
you can read it and
words.
then you can hand it back to me and say, okay, I'm going to ask you again, what was the defendant's date of birth? It was this. Things like that. So there's ways around it. So after that, though, once we get to the defense attorney, they get cross you. It's cross-examination. It's a very different line of questions. And so they get to do what are called leading questions. So my questions, and I make the joke, I say...
Yeah, let's talk about that for a second, right? Because there's a difference in how you ask the question versus what the defense can do.
I say, I characterize it as I have to ask a lot of stupid questions to get to the really question that I want. The defense gets to get right into it. They get to say, a leading question assumes the answer in the question. Isn't it true you didn't get fingerprints? That is a potential leading question. Isn't it true that
you didn't take vitals?
Isn't it?
Right.
So isn't it true? These are all they're more statements typically than really a question. Because you can just say yes, no, which is how they lull you a lot of times, right? They ask these leading questions and it's yes, 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 yes. And then they kind of flip that question that tweaks it a little bit.
That's how we talked earlier, right? And I testified in a trial and that's how he got me.
Yeah. It's
those leading questions.
It's as warm and as comforting of a blanket it should be when I'm directing you. You know what I'm going to do. We've talked about it. We've prepared. I've been available to you for whatever you need to ask questions leading up to it. You should be ready to pounce and listening actively to every question that they're asking you. They're not asking you, I have to ask you a lot of stupid questions to get to what I want. They get to get into it. So if they're asking you questions that you think are not relevant, like we talked to earlier, like, why does it matter how long I worked before? Why does it matter what I ate for lunch that day? They're leading you down a line of questions or getting you comfortable to ask you the really important question. I always say...
And that's what happened to me.
Take the question, think about it, and then give the answer. Don't give them more than they ask you. If it can be answered with a yes or no, Give them a yes or no answer. Isn't it true that you worked 12 hours before? Yes. If they start asking questions that you feel you need to explain, you absolutely can do that. You're allowed to answer the question. If it's a yes, but, you're allowed to do that. Isn't it true that you didn't do this because you had worked 12 hours before? Yes, I had worked 12 hours before. However, I didn't do this because I had worked 12 hours before. I did it because of this. So you're allowed to explain your answer. And I always say, again, part of the preparation is knowing where your role is. So in addressing potential issues the defense is going to come at you on. So many times we have talked about this. So you're going to understand kind of what they're trying to elicit from you. And I always say the best way to deal with it is give them their answer. You can't talk your way around the question. They're just going to ask you again and ask you again and ask you again. Give them their answer, but then explain your answer. That's the best way to handle it. And it's the best way to be credible, right? Questions, and you know what I'm asking you, and you're giving me a direct answer. And then with the defense, you're kind of playing these games, or, well, I don't know, I don't understand, on simple questions, or you don't want to answer the question, they're going to ding you on your credibility. Say, look, they can't even give me a simple answer. Yes or no.
Looks like you're being evasive.
Exactly. And so that's the typical way that they're going to do it. But at the end of the day, regardless of whether I'm asking you questions, the defense is asking you questions, just answer it to the best of your ability, as honest as you can. And we'll deal with the rest of it.
Yeah. Just be truthful.
Just be truthful.
It either happened or didn't.
Exactly. We're not making it up here. I say I live in a world of fact and truth, and it happened or it didn't, and we will figure it out.
Now, after you perform the direct examination, defense does the cross-examination, then you get another bite at the apple, right?
I do. I get to do what's called redirect. I really like to not do redirect.
Okay. Because something's unclear at this point. The water is muddy.
Right. I know exactly what I want from you. If I've gotten it from you, then I will. If I feel the defense has dinged you a little bit, or there's something I want to clean up, that maybe he brought up something and challenged you on something that I hadn't prepped you on, that I feel that I can fix it or I can clarify it to the jury, then I may. But if I do a redirect, then the defense gets to do a recross. So that gives him another chance to ask you more questions. So it's a...
Are they limited in what they can ask you? Is it relevant to only what you said on the stand?
It's supposed to be, but it's not always. So it's supposed to be limited typically to the nature of what my redirect was. So if I'm asking you about specifically about a PCR, but in all honesty, the judges will give them some flexibility. So
at some point, you're going to lose the jury, though, right?
Right. At some point, it's how important is what they came at you on, what they got from you. Does it overcome what evidence we put in? I told you what you're there to do is what's your one purpose, what's your goal on this testimony. And if you accomplish that and he didn't do anything to ding that, I'm good. I'm fine. We don't need to cross it. If you can say, yeah, I didn't do this because I worked 12 hours. That's okay. If it pays no effect on the fact that your purpose there was to say that this person appeared to have a gunshot wound to the chest and that was your sole purpose, who cares if you worked 12 hours and you didn't do an intubation?
So can the judge ask you questions?
The judge can do pretty much whatever they'd like to do. It's not often, but some judges might have a question every once in a while. I can think of a couple times where I've seen a judge that would ask a question. At the end of the day, the judge is listening and they are having to make rulings on the evidence. And so it is important that they understand and they hear evidence clearly. So yeah, it's possible that it could absolutely happen.
What are some final words that you would offer to a paramedic or EMT that has to testify?
Absolutely. You're not there to win the case. You're not there to help us convict anybody. You're there to tell the truth, like we talked about. The case is not won or lost by your testimony. And again, we certainly aren't there to convict. We're there to play our part in the criminal justice system. And that's something that's very near and dear to me. And so don't add that added pressure that you are there to do something specific other than tell the truth. Next is be confident, right? You are the expert in your field. You are being called because of your expertise in providing care or what you did in this specific instance. Be confident that you have prepared in advance. You've thought about the case on your own. You've worked with the state to understand what your role is in this process. And then be honest and be professional. Those are really the key things. This is a lot more controlled than the scenes that y'all show up to. In all honesty, you're there with people who are going to be professional, who are going to ask you questions. What you see on your shifts every day, every night is far more chaotic than what you're going to deal with in the courtroom. So that should give you confidence. And so that's what I'd really end with is you're not there to help us win the case. You're just there to tell the truth. Be professional, be honest, be prepared, and it's okay to be a little uncomfortable. It's nothing more than y'all can't handle.
And most likely you're going to get them on and get them off, right?
I'm going to get you on and off as quickly as possible.
That's great. Excellent. One last question.
Of course.
Right. Do you have any cases that stand out in your mind, good, bad, or indifferent, that you want to share?
There's a lot of cases that are very important to me. There's one case that we had recently. It was a burglary case, and nothing about the case was anything spectacular. We prepared it. The jury convicted the person, but it was just what stood out to me was how grateful that the victim was. It was a gentleman who had his home burglarized, and we deal with a lot of not great people all the time. We deal with people who don't really want to prosecute, who don't want to deal with us. And it's just part of what we do. But this victim specifically was just very grateful that he said, look, I know this is not the crime of the century. This is not that important to you. And I stepped back. It's like, no, like this is important to me. Like this is important. I don't want you to ever think that somebody breaking the law and violating the sanctity of your home is not important. And that jumped out to me. Just it's a nice refresher of how people are grateful to what we do. And we get jaded sometimes because it's call after call after call on your side and care after care after care on your side. And then it's case after case after case on our side. And sometimes we lose sight of those things. We lose sight of the appreciation and the gratitude that people have for us doing what we do. And so that was a really nice moment. I really appreciated that more than he probably knew. And then things that stand out, like maybe on a different side. I had a case when I was still an intern. You just see that there are some good people out there who make mistakes. And that's really important for me to be able to delineate the people who made a mistake and who are otherwise good people. And then you have people who do wrong and they hurt people and there's no remorse, and those people get treated differently. And it's a good dichotomy, really. You look at people who are in the criminal justice system in various different fashions and for various different reasons. And the beauty of my job and why I say I have the best job in the world, because my job is to do what's right every day. And so you get to have impacts on even people who did something wrong. Hopefully you can impact that person to do better. And I say that story because there was a gentleman who had a drug case. It was a pretty significant amount of drugs that he could have been subject to a mandatory amount of prison time. And my investigator and I worked tirelessly to look through his cell phone, and we found out that this was an instance where he was likely trying to commit suicide. He had some family things because of his drug addiction, and I gave him a chance, and I had not given anybody a chance. I could have easily said no. He would have been convicted. He would have done mandatory 10 years in prison. But something told me that this was different. He had family who was there to support him, who was putting it on the line to support him. He had opportunities, and something just said to give him a chance. And this person went through treatment and now has been sober for many years. I actually still randomly will check in with his brother to see how he's doing. And he's turned his life around. He's reconnected with his family. And so you see a lot of negative in what we do, but you have to stop sometimes and realize that what we do matters. There is impact, and you can have a positive impact. My job is not to send people to prison. My job is to do what's right and to try and stop the behavior. And if the behavior that you've done is so bad, you have to go to prison, then that's what it is. But our job is also to try to effectuate change, maybe when you don't want to do it yourself or there's been no other way. And so when I say I love my job, I truly do. I have the best job in the world. Doing what's right is huge. So I would encourage y'all.
That's awesome.
I would encourage y'all just to continue to realize that there is good in this world. There are a lot of good people. And I appreciate the opportunity to be here and talk with y'all and share. And I hope that your audience and your listeners found something and took something from this.
Excellent. I think this was a fantastic conversation. I thank you for doing this, and I think it will make a difference. Thank you so much.
Thank you.
Thank you for listening to In Service, the EMS podcast, where frontline experience meets leadership insight. If you have found value in this conversation, please like, subscribe, share, and leave a comment. You will find links in the episode notes.